Good morning, everyone. I think we've still got some people joining, but it's just gone 10, so I think we'll start because we've got quite a lot to get through. So thank you, everyone, for joining Catherine Wilson and myself, Louise Riedl from Goldhawk Associates, for our online webinar about employment law updates for 2021. Everyone is muted apart from myself and Catherine. So if you've got any questions, if you can put them in the question and answer box. For those of you that haven't met Catherine before, she's a partner and head of employment law at Keebles law firm. Goldhawk Associates have been extremely pleased to have worked with Catherine previously, running breakfast seminars and more recently employment law update webinars. I'm sure a lot of you would have attended the webinars in May, July and October last year. Most of you are aware of us, Goldhawk Associates. We operate in a number of recruitment sectors, including human resources, accountancy, senior finance, public practice, technology, and commercial and business support. And some of you are probably aware that I specialise in human resources recruitment. Now, obviously, the last 12 months or so have been particularly challenging for all business leaders, particularly HR professionals. And we do hope that the content of this webinar and previous webinars we have held will be of use to you as you have made or are making further decisions. So over the next 30 minutes or so, we're delighted to have Catherine provide us with some professional advice and updates that will support you through effective business continuity as we move forward, including updates on COVID-19 and furlough, testing and vaccinations, updates on redundancies and discrimination, as well as disciplinaries and grievances, not to mention Brexit and immigration changes and the ever-looming IR35. I've collated questions that have already been sent to me by some of our participants today, which I'll put to Catherine at the end of the presentation. But as I just said, if anyone has any further questions as a result of what is discussed this morning, please enter them onto the Q&A icon at the bottom of your screen, and I will cover these with Catherine at the end of the session. You should be able to see the PowerPoint slide in front of you. These and a recording from today will be available on our LinkedIn page for any one of you who has missed today's session, or if you want to point it out to colleagues. Anyway, so we've got a good agenda ahead of us. So I'm now going to hand over to Catherine. Thank you.
Thanks, Louise, and good morning, everybody. It's great to be joined by so many of you today. And as Louise has said, it's our fourth virtual event. We had hoped by now that we'd be going back to the rather delicious bacon sandwiches at the Maidstone village, but sadly not. So we're going to make the best of what we can. So if we look at the next slide, you'll see that I've got quite a full agenda of the things. And I had hoped that today we wouldn't actually have to talk about COVID at all, because I'm sure we're all heartily sick of it. But sadly, no, we still have some other issues to do it. I've got a message saying that the audio is not great, so I'll try some different headphones if that works, but please let me know if you've got any problems. First thing I'm going to talk about is COVID, testing and vaccination, update on redundancies, disciplinaries, grievances, discrimination, Brexit and immigration changes, IR35, and as Louise has said, Q&As. So assuming that the audio is working a bit better now with these headphones, let's move on to the next slide. So I think we've been waiting for furlough to end, and you'll notice the deliberate mistake. Even I don't think we're going to have a furlough scheme until 2030. But what seems clear is that the current scheme we know is going to go on until April 2021. Which is clearly a relief to many of us, and particularly because it gives us some certainty. And what I'm going to talk about today is highlight really all those different sections which make it different, because as the rules on furlough have changed, so have the impact on employers really. And the three things I've really touched on are flexi furlough. If you could think back to March, we know that there were very strict rules about how long furlough could take place, and it was a very fixed and inflexible model. Then in July, we moved to what we call flexi furlough. And if I look at the clients that we have then who are still using furlough, they are certainly using it as a combination of working normally and indeed reduced hours. So no minimum periods definitely gives much more flexibility. I think it has made the administration of the schemes more difficult, particularly in terms of calculating the salaries and the claims. And we know that the revenue is particularly exercised, one about fraud, but also about incorrect claims. And I think that's something really to stress. The second point is that there is still no legal obligation to furlough. Martin Lewis might suggest that it's immoral not to furlough. Other people might suggest that it was immoral to furlough in circumstances where there is no ongoing likelihood of a role. But the key thing is there is no legal obligation to furlough. And we're already beginning to see, when we look at the tribunal claims that are creeping through, that in fact it has been suggested by a number of claimants and their representatives that actually a failure to furlough renders a dismissal unfair. We won't know probably until next year whether or not that is actually the view taken by the tribunal, but I would hazard a guess to suggest that it won't be as clear-cut as that. It's certainly something which an employer would be expected to consider, let's say, as an alternative to redundancy, but consideration is not the same as obligation. We also know that there is no obligation to furlough, for example, where an employee has significant childcare responsibilities and particularly homeschooling. Again, though, any refusal to furlough following an express request would need to be documented, and you'd need to have a clear understanding of why, particularly flexi furlough, would not be appropriate in those circumstances. I think the other point I would make is that we are being asked increasingly by clients whether or not furlough could be used, for example, as an alternative to paid suspension in a disciplinary because of the saving of money involved. One can appreciate the financial benefit in relation to that, but I don't think furlough really can be used in that particular way, and I would see that as a misuse. Why does that matter? Well, it matters for all sorts of reasons, but it certainly seems likely that their employers will be pulled up on attempts, shall we say, to subvert the system. And we know now with the latest website disclosures from HMRC that the 700,000 employers who use furlough in December are now open to scrutiny across the board. And I think that does make quite a difference. And individual employees can see via their own online tax accounts whether or not claims have been made. So very difficult for those employers who were claiming furlough whilst continuing to retain those staff. So I think there is a greatest level of scrutiny. And again, it makes it even more important that when we're making that decision to furlough, we document it and use it in an appropriate way. And as I say, we don't try and game the system. And then the third point on the slide I wanted to raise is this furlough versus notice. Under the existing and the old furlough scheme, it was possible for an individual effectively to be furloughed whilst working their notice, thus securing at its high 80% of the capped pay, which was clearly quite a big incentive and also great financial assistance to the employer as it paid effectively 80% of their pre-existing liabilities. Sadly, I think that ruse has been discovered and you are no longer able to use furlough to cover that notice period. A couple of points to make in relation to that, though. You can still consult with an individual whilst they are being furloughed. It's only when that consultation ends and they receive notice of termination that the notice period, whether it's worked or paid in lieu, has to be out with the furlough system. So a significant change and one which is definitely worth bearing in mind if you are unfortunately looking down that redundancy route. So next slide, please. We're increasingly being asked a lot of questions, particularly about vaccinations and testing. So I thought it would be worth highlighting that on this particular slide. Now, clearly, in relation to testing, I think it seems pretty well accepted now that testing and the requirement to test is a reasonable instruction. You can't force anybody to be physically tested. That's what we call a criminal assault. However, it does seem to me quite credible that it will be a reasonable instruction, even if you do not have an express contractual right in your policy, and very few employers do, to test in this way. However, you'd obviously have to be careful to distinguish between the refuseniks, as I call them, and those people who have a genuine reason for not wishing to be tested. I suppose a paranoid fear of needles perhaps would be one reason, certainly something you would need to document. And I know there has been some suggestion that it may be discriminatory to take disciplinary action and or dismiss for a failure or refusal to test. I also think the sector is important. So if you were involved in a social care function and or a business where, for example, involves going into people's households, particularly elderly, vulnerable people, then again, I think it would be a reasonable instruction to expect that your staff partake in testing. The vaccination situation, I think, is somewhat different. At the moment, we know that unless you are a frontline healthcare worker and or I think aged over 70, depending on where in the country you live, vaccinations have not really had any real impact on the working population at all. However, by the summer, so now is a good time to start thinking about it, those vaccinations will be far more widely available. And we are being asked for our view as to whether or not the situation of vaccinations is similar to that of testing. And you will have all seen the well-vaunted discussions prompted by Pimlico plumbers, who must get an awful lot of free publicity for their employment practices, on the basis that they would not employ staff who had not been vaccinated. Now, clearly, employing new staff is somewhat different to what you do with your current staff. And again, a precondition of contract arguably could be reasonable, depending again on the type of job and the business and operation that you're in. So if you're a care home, we could imagine a situation where it would be a reasonable precondition of employment, for example, for the individual to have been vaccinated. I think it would be far more difficult to argue that situation if you are in a different environment with a relatively low risk. I think there's been a lot of discussion in the media about whether or not anti-vaccine per se is potentially discriminatory. I think there are some arguments in relation to that, but again, we know that if there is a requirement that staff be vaccinated, then that clearly could mount an indirect discrimination claim, potentially on grounds of race, and indeed other grounds, which I'm going to come on to in a minute. However, it would probably be possible to justify that requirement, depending again upon the sector in which you are operating. I think a one-size-all for many businesses may not, however, be appropriate. So that, let's say, if I'm a manufacturer of aids to the elderly, then clearly my salespeople, the staff who install the equipment and deliver it, I think they ought ideally to be vaccinated, but backroom sales staff query whether or not there is the same requirement. I do not see, though, the government introducing a mandatory vaccination. They failed to introduce mandatory vaccinations on grounds of human rights and all the rest of it for other areas, and I think the same will be true here. I do think, though, that those issues of discrimination, we've talked about race, but again, religion, belief could also come into play. And I've put on the slide the concept which is gaining some traction, which is that genuine belief in anti-vaccination could in fact fall within the definition of the philosophical belief. I think that's based on various grounds. To counter the philosophical belief, it has to be genuinely held, and it has to be something more than opinion or viewpoint. In fact, the legislation talks about a weighty, substantial aspect of human life. So again, quite a high test. But we know that veganism, for example, and I'm going to talk about this in the discrimination section, has been held to be capable of being a philosophical belief. So I think it's possible, though I would suggest unlikely. And then the other element I wanted to really stress are the issues of confidentiality and data protection. Clearly, if the fact that an individual has been vaccinated is going to be such a crucial part of the recruitment process and a condition of employment, it will be necessary for those records to be retained. I think there needs therefore to be very careful attention paid to how that information will be retained and who will have access and what will it be used for. So possibly something to check with your data protection and document retention policies, just to make sure that you are compliant. As I say, I think this is unlikely to become a pressing issue until later in the year when we have a higher level of general vaccination, but I think it's definitely something which will need some consideration at this early stage. So that was all I was going to say today about furlough and the related provisions. But if we go on to the next slide, I think we've all begun to see in terms of redundancies that this is one of the consequences of the COVID pandemic, which will have very long-reaching impact. So in September, there was a joint statement issued about how to handle redundancies in a pandemic. And rather like dealing with disciplinaries and grievances, this has not been straightforward. However, in the intervening 6 months, I suspect we've all become a lot more familiar with it. Key point to say is that this statement does not have legal force. However, it is definitely something which, if you're in charge of HR in your own organisation, you should be familiar with. Deals with issues such as consultation on Zoom and Teams. How do we ensure that there is an adequate consultation, both individually and collectively? And ideally, one should be referencing it in your general notes. So, for example, I think if one is making an announcement of redundancies, you would probably expect to see some comment that regard had been had to this joint statement. As I say, not mandatory, but definitely something which, in my view, would count towards being seen to have dealt with things in a reasonable fashion. So, I mean, 5 principles which are inherent in this statement, and I think are probably motherhood and apple pie, really. Openly, thoroughly, genuinely, fairly, and with dignity. My other view to that is carry out the redundancies in a way which you would like to be treated if you yourself were being made redundant, and you won't go far wrong. There is a new HR1 form. We know that for all redundancies of 20 or over, there is an obligation to inform the government of the types of those redundancies, the timing, etc. It's a public document. It needs to be shared with your collective representatives, be they the union and or the elected reps, as I say, for these larger redundancy exercises. I think I've been pleasantly surprised, probably for the first time in my not insignificant length of time in practice. A number of clients have actually been contacted by the relevant government departments following receipt of these HR1 forms. I think hitherto we've had a view that they were sitting in some pile being ignored. And I think that there has been offers of help and assistance, and indeed officials have even virtually done Zoom calls and Teams calls with affected staff. So it's had slightly more impact than it has had in the past. And then the third final point I wanted to raise is this pregnancy and maternity redundancy protection bill. We know, unfortunately, that for a whole range of reasons, many of which I'm sure were unintended, there has been a significantly adverse impact upon female workers as opposed to male workers, and in particular those individuals who were either pregnant, maternity returners and the like. So this legislation proposes an extension of the existing protection. At the moment, women who are pregnant and returning from maternity leave effectively secure an enhanced level of protection and options, if you like, for jobs. This will change if this becomes legislation. And what this is proposing is that you are protected from the minute you declare that you are pregnant, and indeed you return to work, and for a 6-month period after that. So if an individual took the full 12 months leave, it's quite conceivable that they would be protected for over 24 months. And in those situations, they cannot be made redundant, according to this legislation, unless the business is closing down or ceasing work in that area. So if we go back to the test of redundancy, it's either disappearing workplace or disappearing job. And indeed, if this legislation comes into place, you would have to pay far more attention to those reasons. So if let's say we were looking to reduce from 5 to 4, then the individual who was returning from maternity leave would effectively be ring-fenced. So it will be a significant change and another consideration, if you like, or factor when we're looking at redundancy selection. And the protection, as I've said, could be quite lengthy. 2 years, as I say, does not seem to me to be an unlikely estimate. So moving from redundancies, COVID or no COVID, if we look at the next slide, we're going to talk about disciplinaries and grievances. And these have happened, again, throughout the process. I think, again, there is an ACAS guidance, and just like you should be looking at the ACAS joint statement, again, it's important that you look at the ACAS guidance on disciplinary and grievance procedures during the coronavirus pandemic. Catchy title, huh? Again, it's not a piece of legislation, but it goes to this whole concept of what is reasonable behaviour. And we won't know until the cases come to tribunal, as I say, probably next year, as to whether or not the adjustments that were needed because of COVID, in terms of the way in which those hearings were conducted, has that rendered them fair or unfair? I think there are several practical comments, though, that I would probably draw your attention to. We have seen a lot more disciplinaries and grievances conducted remotely, particularly on Zoom and Teams. I think there have been particular challenges with the right to be accompanied, particularly in those non-unionised clients. I think as well, we've seen a massive upturn in what I would call illicit recording. I would suggest that at the beginning of each hearing, you specifically ask the employee whether they're recording the proceedings and or whether they are alone if they're not actually exercising their right to be accompanied. We've seen a lot, as I say, of recordings, but we've also seen a lot of situations where in fact several people have been present when it apparently has supposedly been a sort of one-on-one or two-on-one type situation. Again, I think you need to refer to this grievance and say that you've considered it, both in terms of the operations and how you've conducted the various hearings, but also in terms of any decision that's made. I think if you raise it and reference it, that will be awfully helpful if we end up in a tribunal at some later point. And then I also wanted just to touch on some of the cases that have been dealt with last year, and which I think in ordinary times would have been given quite a lot more publicity. The first case is the Gillian Smith matter, and it talks about she effectively was the chief executive of a charity, Age Concern in Exmouth. And those of you who've been involved with charities will realise that they are fairly unusual organisations, and that they can sometimes be a very uncomfortable or perhaps over-enthusiastic relationship in terms of the trustees. Many charities have in fact users as trustees. A number of the trustees have benefited from the charity and or are founding it. So there tends to be a bit more of a blurring of the normal operational lines between what we call the executive or senior management teams and the non-executive or trustee teams. And so it was in this particular instance. I think they had recognised that they had a potential problem, and therefore they had created a protocol. And we lawyers adore these protocols. We love there to be clarity about who is responsible for what. However, at the same time, this can be quite problematic if you don't comply with the protocols, and thus it was in relation to Gillian Smith. There were two particular instances which I would summarise, and they may sound familiar to many of you. The first one was that she witnessed a verbal dispute between two members of staff, including lots of bad language, far too foul for 20 past 10 on a Thursday morning. And when she stopped them and challenged this behaviour, one of them stomped off site and said she could stop her job where the sun did not shine. She took this to be his resignation from post, and effectively treated him as having resigned. He then brought a complaint to the trustees, who effectively upheld his complaint without any reference to her, and indeed wanted him to be reinstated, which she felt was incredibly undermining. I think part of the issue was the fact they hadn't even discussed it or investigated it or found out the background. Then the second incident involved another member of staff, where she had determined that after a long period of very poor attendance, they should move on to statutory sick pay rather than contractual sick pay. And again, the trustees intervened and overturned that decision. So it's a rare example of a constructive dismissal claim, and effectively shows the importance of complying with any policies that you have. We're not saying that appeals should never overturn earlier decisions, but I think there is a question of process. And certainly, I think some discussion with the original disciplining officer or dismissing manager will be a key part of that process. So, yeah, interesting case, gives quite a lot of learning points out with the actual charitable sector. The second one, Ken and Ure, could be described as never worked for a family business. Effectively, it's a care home business in which both father, mother and daughter worked. Father decides to leave mother to go off with other co-employee. At about the same time, daughter goes on maternity leave. I think it would be fair to say that the actual treatment of this woman on maternity leave is probably a case study now not to do it. They varied her pay, they didn't give her the information, they didn't calculate the pay properly, they generally behaved in a fairly tawdry way, and she failed to return. Key point here is that obviously if you claim that you've been constructively dismissed, there is an onus on you as the employee to explain that you have been constructively dismissed. The view here, though, was that she failed to return, that they should have investigated it, and they couldn't therefore get out of the fact that they had constructively dismissed her because she had just simply failed to return. I think there's also a more recent case which was heard earlier this year, which again is about this constructive dismissal point, and a case of Gordon and Pierce. And what Gordon and Pierce says is that if the employee issues a grievance, that does not mean they have affirmed or confirmed or ignored the breach. I don't think any of us ever really thought that. And in fact, that's why as lawyers, we always say if somebody does resign unexpectedly, you should always challenge them and give them some breathing space to consider it. But certainly, I think it's an action point for us all there. Tan and Copthorne Hotels, I would say, is a slightly more positive case from an employer's perspective. You'll all have been told by your lawyers that effectively, if you go to tribunal as the employer, you're very unlikely ever to get your money back, and certainly not the excessive, I would call, value costs that you might achieve. However, this is an exception to that rule. He was a procurement director working for the hotel chain in Copthorne. He made hundreds of covert recordings and came up with numerous different courses of action, hoping, I suppose, that one might work. Tribunal were very unimpressed with his behaviour, felt he'd behaved in such an outrageous way that they ought to award costs, and they did, in the sum of £432,000, which is the largest costs award any tribunal has ever made, and I would suggest is probably ever likely to make again. Although you see when we come and look at some of the different cases that in fact there have been more costs awards made. And then the final point on the slide is a very instructive case. Many, many years ago, there was a case called Linford Foods, which was involving the informant evidence. The informant was commenting about theft, but it was all done anonymously. And there's always been some unease about relying on anonymous or informant evidence as the basis for gross misconduct. So what happened in this case was that it was a housing association. A tenant witnessed the claimant, who was a long-standing carpenter, making homophobic remarks. The claimant was spoken to as part of the investigation, but was not spoken to as part of the disciplinary. And the concern was raised that it was unreasonable to rely on this informant evidence. But the EAT felt that that too was in itself unreasonable, and that the guidance in Linford Foods, which is that you can rely on informants so long as you're satisfied that the informant is not acting in bad faith, and or you've challenged why they can't appear, why do they need to retain in this, well, they need to retain anonymity. What happened in this case was that the informant, suffering from an anxiety disorder, was in fact in receipt of disability benefit, agoraphobic. So her justification for wanting to stay anonymous and not participate in the disciplinary process was genuine and substantial, and that there were no reasons to think that she had any particular axe to grind or indeed was acting in bad faith. Wherever possible, of course, and you see this particularly in sexual harassment and related cases, ideally the complainant certainly would be prepared to step forward and not remain anonymous, and always encourage you to encourage them to put their name to the allegations, because ideally handling these anonymous allegations definitely weakens the claim and makes it far more difficult to progress. But it is possible not to go ahead without them. So moving on to the next slide, we're going to look very briefly at some of these discrimination matters. When you look at the slides, you might think that the NHS had nothing else to do but to deal, unfortunately, with some of these claims. I don't think they have more claims than other employers simply because they're bad employers. I think possibly they are overgood, in the sense that I think they have too many policies, and the more policies and procedures you have, the more likely it is that you're going to get it wrong. And thus it is in these two age claims. I think Eileen Jolly needs a medal. She's an 86-year-old administrative worker. There were concerns about her capability, about whether or not she could actually walk around the hospital due to her age and underlying health issues. So they decided that they would suspend her pending a capability hearing. Problem with that was that their performance management process or capability process did not include a suspension. So the view was that that was a breach of contracts, and certainly the tribunal weren't at all happy with that and awarded her £200,000 in damages. Ryan and South West Ambulance Services is similar in that we're talking about the impact of a career plan, really. They had a talent pool plan, but to be in the talent pool, you had to have been graded as exceeds in your appraisal. This individual felt that both the talent pool and the approach were indirectly discriminatory against her because of her age. That was actually rejected, but I think what comes out of the case is that whenever you're introducing something like a talent pool, you must make sure that you do some type of impact assessment and see whether or not there would be particular groups who would be adversely affected. So an obvious example would be if you have an undue reliance, shall we say, on post-qualification experience, that could be indirectly discriminatory against women who tend to have more career breaks, would find it more difficult to meet that 10-year, let's say, requirement. Having said that, you can still have the 10-year requirement, but you need to be able to justify why that is required in relation to the objective you're trying to pursue, i.e. presumably, as in the Ryan case, this talent pool. So we're not saying you can't do it, you just need to justify it. And again, if we look at the disability discrimination claims, all of which relate to mental health. I can't remember the last time I've ever advised actually on a disability claim that was not connected to mental health or stress. But there are lots of practical things that come out of these cases, which I'm going to highlight now. The first is in relation to the Hill case, is that they talked about the impact of mental illness and bullying, but they also talked about what would be reasonable adjustments. And I think this is probably the most instructive part of the case. And what they said was an undertaking not to make an employee work with those individuals who bullied and harassed her would be a reasonable adjustment. Or similarly, the option of a severance payment would again be a reasonable adjustment. When they were calculating the severance payment, that did not have to be equivalent to the enhanced redundancy type of payment. So I think that's quite useful. Again, we look at the Department of Work and Pensions and Boyers, long-term sickness absence over a 10-year period, workplace stress. Again, they stress the need to balance the legitimate aims of the business. The view here was we need to have staff who can turn up and provide a regular level of service. We're putting undue stress on the co-workers, but also the impact on the employee of being dismissed. But so long as that balancing act took place, it will be a permissible option. And the last one, I'm not even going to attempt to pronounce this gentleman's name, but the TSB case, individual had just under 2 years, which you might think would be significant. I couldn't possibly comment on that, but effectively tried to allege that he had a mental health disorder following the death of his father. The view of the tribunal was that he may have had significant issues to do with the bereavement, however, that was not a disability at a relevant time. And there was a certain amount of cynicism, shall we say, expressed about the fact that he was trying to find some particular cause of action which could get around the 2-year rule, but again, couldn't possibly comment on that. So move on to the next slide on discrimination. Samuel Jackson and philosophical belief. He's not the Hollywood actor, but in fact was a store worker at Riedl. And his protected characteristic was philosophical belief, namely stoicism. You could perhaps work out what stoicism is, but effectively what it seems to say, I understand it to mean is that he argued he was bound to say what he liked, took a perverse joy in advocating views at odds with common sense. Could say a lot of comments about that, but it's certainly quite interesting. And their view was that that was potentially a philosophical belief. He was obviously going for the double whammy because he also said that because he was dyslexic, he missed his words, and that's why he couldn't apologise. So there is a, I'm going to take your hat off, but it's certainly an inventive way of trying to get yourself some type of protection. And then the next case involving the League Against Cruel Sports was something we've already touched on, which is like ethical veganism. So more than simply dietary restriction. And again, the view was that looking at the test, that could be part of a philosophical belief. Next couple of points I just want to flag up are about gender reassignment. We have seen an increasing number of claims here. The protected characteristic is gender reassignment. We don't talk about transgender in the legislation, but in fact they're now being used interchangeably. But the important thing about Taylor and Jaguar Land Rover is that it establishes that if you are non-binary, then you can still fall within the protection of this definition. Hitherto, there was an emphasis on whether you were only protected if you were proposing to reassign your gender or you had reassigned your gender. But now that seems, at this court decision at first instance, to have been rather more extended, which again, I think is a point to look at. And in fact, I've just written an article about this on LinkedIn in more detail. So if you're interested in that, please look at my page. I think the other key thing to say about this, though, not only does it mean that people who describe themselves as gender fluid and or individuals who dress, for example, in women's clothing, arguably seen to be protected under this protected characteristic, but the case itself highlights all of the same types of failings which we see in relation to other types of discrimination. So she was subjected to insults, bullying, there was insufficient management support, insufficient training. That could apply across any of the protected characteristics as set out in the Equality Act. So it's definitely a case that is well worth a read. And then finally, and I think we've done quite well getting through a session without any comment about social media, Higgs and Farmer School, Christian school assistant, in her private capacity on her private account, without any reference to the school, liked some comments to the effect that LGBTQ teaching in primary schools was inappropriate. The school's policy was such that effectively they were found to have fairly dismissed her because there were clear expectations, and that effectively, as far as they were concerned, if you were working in school in any capacity, then nothing was truly private. Obviously discovered because, as everybody does, had a whole range of different friends who happened to work at the school as well. The thing for me about that is it shows yet again the importance of having a strong social media policy, particularly if you're going to try and enforce these types of expectations with your workforce. So, conscious of the time, we're now going to talk a little bit about Brexit and the immigration changes on the next slide. So we know free movement ended on the 31st of December 2020, and therefore there has to be a licence to employ. So there were changes in terms of immigration. I think the key things I wanted to flag here are that until the end of June 2021, your EU staff are entitled to work and need to register under one of the settled status schemes. There again, there is an ACAS code to deal with this as well, isn't there, for everything? But in any event, it's clearly in your interest to encourage them to do so, because if they do enrol for either the pre-settled status, so they've been there for less than 3 years, and settled status for over 5 years, gives them access to the NHS, education, and more importantly, enables them to continue working for you. We talk about sponsor licenses, and we could probably talk about these in some detail. The key thing is, if you think you're going to hire overseas staff, you need to be looking at getting one of these sponsor licenses. They are not expensive. They last for 4 years. And I think we would strongly recommend staff and employers who are interested in that area to take those steps. Key points again are proof of right to work checks. These may have been suspended in terms of format, but they have not gone away. And since March 2020, scanned documents and looking at those key documents about proof to work virtually on video calls has been acceptable. However, we know from the 30th of June that there will be a retrospective checks introduced in terms of this right to work 8 weeks after the measures end. So for those staff you've employed in the last year, you need to make sure that you do have those records and that you can demonstrate that you've checked them. Doubly important, of course, because you will find it very difficult to get one of these sponsorship licenses if you are perceived by the Home Office not to have complied with these proof of right to work checks. Another key area is if you think that your organisation is likely to wish to be sold in the near future, we are seeing in terms of due diligence queries a lot of emphasis on has the employer carried out and recorded the appropriate right to work checks. So from all different angles, this is again another area which I think is well worth paying attention to. Okay, next slide is about IR35. And in fact, we have a couple of questions about this, but so I'll probably go quite quickly through it. This is not a new provision. IR35, which is about trying to equate off-payroll contractors with equivalent employees in terms of tax and national insurance, goes back to 2020. In 2017, we know that it was introduced into the public sector. And the key point really is that it shifts the burden from me as contractor being responsible for my own tax and national insurance and informing you as the retainer of my services, what you're prepared to pay. It switches that liability back onto the person buying the services rather than from the provider. So I think the jargon we talk about shifting from the contractor to the end user only applies to large and medium sized employers. So what do we mean by that? Well, effectively, you are a large or medium employer if 2 out of the following 3 criteria apply. So you have a turnover of 10.2 million, you have a balance sheet of 5.1 million, and you employ more than 50 employees. I would say that is a pretty broad definition, and it is designed to catch as many people as possible. The starting point for many of you will be the HMRC website, which contains an online checklist. I think the key thing to say in relation to that is that that is not binding, and that there are several elements of that checklist which can determine the outcome according to the checklist, but can still be reviewed by HMRC. So given that we have a couple of months to go, I thought it would be just worth highlighting in a practical sense some of the criteria. Key point is that the IR35 checklist tries to deal with what is inside IR35. And the key one I would draw your attention to is the worker carries out the work personally. There is no entitlement to substitute. If you want to make sure that the HMRC checklist says that the individual is outside IR35, all you need to tick is the box that says they are allowed to provide a substitute. If the matter is challenged, however, it doesn't quite work in that way, and they will look at whether or not the individual ever has been substituted or whether in practice you would ever allow this. Lots of other things which would be indicative of IR35. I've seen clients where workers have supposedly received paid holiday and sick pay. Again, very unlikely to be outside IR35. Paid on a time basis, paid on close supervision, supplying the equipment, etc. I think we have had a double upsurge in relation to this, because we have seen a number of clients who, as part of a redundancy consultation, have taken the view that they can actually pay the redundancy and then a week later bring the individual back as a contractor. That seems to me to be quite a high risk strategy. Up to April, it will be for the contractor to try and resolve these issues. Post-April, you as the end user will be liable. So very important, again, that you take action to review this at this point. And the key points I would say are, start off with, is you need to determine the employment status of every contract you agree that is in fact going to be going post-April. I know that often these contracts are entered into by the operational and the line managers, are not shared with HR, notwithstanding the fact that clearly you need to be aware of them. Also, they're not formally on payroll. They may not be on payroll, but you do need to have that determination. And we talk about communicating the determination using what we call a status determination statement. And I have a question about that later, so I'll probably come back to it. But in essence, this needs to be passed to the worker, and it needs to give the reasons for the decision. I think the other key points to make are, when you've worked out how many of these people are potentially caught by these reforms, we need to start talking to the contractors about whether or not the off-roll payroll rules apply. We need to do that before we carry out some of these formal status determination provisions. So I think we move further on to the last questions. Those are all I wanted to say. So thank you for your perseverance. I have a couple of questions, but what I'm going to do is hand back to Louise and see whether anybody's added any questions to the Q&A box.
Thank you, Catherine. That was some really interesting content there. Right, so you've got the questions I emailed you. There are a couple in the box which they're both very similar regarding notice and furlough. So if I read them out, you may have covered them, but we can go back over them if necessary. So what about notice if an employee resigns when on furlough is one question. And then another question, which looks very closely linked, is someone's sound dropped out when you were talking about furlough and notice when redundancy is the only option. So they've asked if you could repeat that bit.
Yeah, of course.
Section. So do you want to cover those? And there's one other question regarding Brexit, but maybe if we do the furlough ones to start with.
Yeah, that's absolutely fine. If we look at the notice if an employee resigns when on furlough, I think the view, I mean, it's a very good question, is the answer. I think it depends on whether or not they're giving purely their statutory notice or whether they're actually complying with their contractual notice. But I think the argument must still be the same. Even if the individual is giving notice, then they're giving their status as an employee under notice, not a status of an employee on furlough. So they would need to be paid appropriately for that. But I have to confess, I haven't actually come across that at this point, so I'm happy to check that out. But that would be my understanding of it, Amy. So I'll certainly come back to you with that via Louise. That's no problem at all. And then in terms of furlough and notice, the key point is if we serve notice to an individual who's currently on furlough, then when then that notice has to be paid as normal. They come off furlough effectively, and then they are on notice or paid in lieu of notice, but you can't claim the 80% back for that period. So hopefully that makes that clear. So Nancy, don't know when it's going to come into place. I would imagine probably the autumn, but there is a lot of enthusiasm about that, because as we can see, there have been a number of cases where individuals appear to have been frontline, if you like, in terms of redundancies. So I think there is a real need, or perceived to be a need, to strengthen the protection. So I think it's a watch this space. I would think it would be sooner than later, though. Okay, there was a Brexit question which I think has dropped out.
Okay, it's right at the bottom. Can you see it, or do you want me to read it out to you? So
if you could read it out to me, that would be great.
No, that's great. So will employers need to check and/or store settlement status of their existing employees, or only of new employees joining post 30th of June 2021? And what if an existing employee hasn't applied for settlement status?
Well, if the existing employee hasn't applied for settlement status, they have until the end of June to do so. So we need to be strongly encouraging them, supporting them to do that. Because if they haven't got that, they lose then. If they don't get that settled status, they then lose the right to remain. And obviously it makes it very difficult for you to continue to employ them. So you definitely need to be flagging that up with them. You always need to know for all of your staff that they have the right to work in the UK, whether they've been born in Maidstone or wherever. So I think the key point is it would apply to everybody. So I would definitely advise clients to keep a record of that settled status, because if there is an audit, they would want to see that you have proof of their ability to remain and to work, which is why obviously as part of an induction and the start of recruitment, or indeed for some cases even before that, people supply proof of their passport, etc., to show that they are free to work. So I think the record keeping is important, mindful, of course, of all those data protection obligations as well, about how you secure that data, who has access to the data, and how long do you keep it for.
There's another question on settlement status in the chat that's come up. If the existing staff have not provided the settled status by the date, then would we dismiss by frustration? How long would you give them past this date?
Yeah, I think that's a really interesting question. We know already in other areas where an individual's work visa, let's say, has expired, the view of the tribunals or the employment tribunals is that does not mean that the contract automatically becomes void. It is what they call voidable. So it almost stays in the ether whilst, for example, the individual appeals against it. And I think we're not sufficiently sure. I think there will be some flexibility even at the end of June. And I suspect there'll be a further grace period. But again, that's why I'm so hot, if you like, on encouraging people to apply for this settled status as soon as possible. And we know that millions of people have, but we know that there's still a significant number who have not. So I think there's a bit of uncertainty about whether or not there will be a grace period. Certainly, you cannot employ, the argument is, how can I employ somebody who's not legally entitled to remain and work in this country? Therefore, looking at the other case law, I think subject to any appeal, that would give you reasons to terminate the agreement, let's say using some of the substantial reason route rather than necessarily frustration, because whilst frustration as a contractual concept is certainly completely legally correct, there is a reluctance to use it in the employment tribunal arena. I think it works better in commercial contracts. There is a nervousness about using it in tribunals. So aside from frustration due to long-term prison sentences and death, there's usually a bit more wiggle room. So conscious of the time, I've got a couple of other questions as well, which I'm quite happy to go through. The first is, if a hirer is asked to give a status determination statement, can this be used as a defence if HMRC determined that the statement was incorrect? So hire a TELS contractor that they fall outside IR35 when HMRC determines they fall within. So what they talk about is the client taking reasonable care when forming the decision regarding employment status. And this definition of reasonable care, which is the defence effectively, is a subjective one. And we know that there have been a number, particularly in the public sector, who've made what you can only describe as blanket assessments. And surprise, surprise, those blanket assessments tend to be that they are within IR35 rather than, I've not heard of anybody making blanket assessments to say that they are outside IR35. And I think when we look at the commentaries, the way you can show reasonable care is by acquiring legal advice, by looking at some of those tests and the criteria that we talked about this morning, and specifically making full assessments on an individual basis, with the general consensus being that if you're carrying out a blanket assessment, that does not count as reasonable care. Who's liable for underpaid tax? Well, post April 2021, it will be the client or the end user assumes the position of fee payer. And if you're the fee payer, you assume liability for any tax and responsible for reporting and deducting tax from the payments. So hence why it's so important to do that audit now, particularly for those contracts that are going to go on post April, and make sure that you don't get caught by that liability. There's also some specific questions about if the contractor is operating as a limited company or using an umbrella company. I think from the end user's perspective, they're probably not as significant as they are from the contractor. If you look on LinkedIn, there are hundreds of companies who are happy to offer you umbrella companies and assistance on paying no tax. I'm afraid that's not within the scope of our talk today. However, I think it's fair to say that there is a general feeling that if you have set up your own limited company with all the costs associated with that, it is easier to demonstrate that you are out with IR35 than, say, a single sole trader individual. Umbrella companies are different again, because effectively the contractor becomes the employee of the umbrella contractor, and the umbrella contractor deducts the tax and national insurance. That has the benefit of ease from the contractor's perspective, but is a lot less lucrative, shall we say, in terms of how much income they retain. So the level of take-home pay generally works out less than a limited company. Both the limited company route, though, and the umbrella company are better in terms of indicating an outside IR35 status. And of course, because of the umbrella company, they're not really independent at all because they're taxed as employees. And then the next and the final question, again, is about the vexed question of holiday year. You'll remember back in March, there was a great deal of concern that if all the people who had accrued holiday up to the end of March took that holiday, particularly in the health service, we would have a massive issue with capacity. So the view at that point was that the holiday accrued as at the end of March 2020 could be carried over and taken into the next 2 holiday years. So I think that remains the case. People can be encouraged, but that they have that lengthy carryover, even if the contract says something different. And most contracts do allow some carryover, but a lot less, and certainly nothing as generous, if you like, or broad. We know, though, that there have been specific rules in this coming up to this next financial year end, with people not being able to take holiday. And there, I think the position is a bit more fuzzy, shall we say. I think the general view is that the normal rules apply, so that employers can always insist that employees take holiday. And there is a view that if you want to take 2 weeks holiday, you then have to give the employee 4 weeks holiday. My starting point with it is always to make sure you do an audit, and that should have been happening throughout the year, so that individuals were not able to build up great wodges of untaken holiday. However, I think that might be a bit of the counsel of perfection. But the general view is that going forward, people, for example, in the new holiday year, assuming the holiday year follows the financial year, will, I would say the norm among clients is to allow people to take over another 10 days on top of whatever they could have taken over back in March 2020. Incredibly complicated area, however, and I think our advice has got to be that employers need to do everything reasonably practicable to encourage staff to take as much holiday as possible in the year to which it relates. We know, of course, that the starting point in terms of working time holiday so the 20 days plus the 8th bank holiday, is that should be used and should not be carried over and not paid in lieu unless the individual leaves employment. And I think there will be quite a strong impetus to go back to that fairly draconian, you might say, but clear rule in future years. So those are the questions that we had. I don't know whether we've got any other questions, Louise.
Yeah, there's one more on the Q&A. Once an employer has determined that a contractor will be affected by the IR35, do they then need to inform the HMRC of this? What's the next steps?
Well, if they're going to be caught within IR35 post-April, you need to be looking at the contractual arrangements. And yes, because the responsibility will be falling on you as the end user, then yes, they would need to be added, as I understand it, as another employee. But obviously, that's something to be negotiated with the particular contractor, who may not be happy to continue on an employed basis. I've heard that quite often. And the other thing as well is that a lot of contractors have multiple contracts with the same organisation. So they may be within IR35 for some elements of their work, they may be outside it for others. So I think, yes, if you're going to be liable, then clearly they need to be paid via HMRC and via tax, but that has to be agreed. And you may find that some contractors will be happy to become effectively employees, other contractors may not and may cease to carry out the work. But I can't see how you could be criticised if you decide that they're within it and you contact HMRC and you proceed on that basis.
Right, I've just thank you, Catherine. There's a couple more questions I've just seen on the chat box. So we are skipping around with topics here, but so someone's put, we're asking all teams to take holiday before the end of the year as businesses on a skeleton team only. Is this acceptable as a couple of the team are asking to stay on furlough and have their holidays carried over?
Well, they can take holiday while they're on furlough. And I've encouraged a number of clients to do that, to avoid this whole situation where you've had an individual who's been furloughed since March and then comes back with another 30 days holiday on top. So I think that is permissible. We know that you can, the accrued holiday up to the end of the last financial tax year is different. There is a specific provision for that. But if we're looking at holiday accrued during this current holiday tax year, then you are entitled to ask them or indeed insist that they take that holiday. But do remember that if you're going to force them to take holiday, you have to give twice the notice. So if they want a week off, you have to give them at least 2 weeks notice. And clearly, because they can take holiday on furlough, then you can get the 80% back, but you'd have to top it up to the 20%, by the other 20%, so that they get 100% of pay.
Brilliant, thank you. Right, and then we've got one more Brexit question. Employees who move to the UK after 31st December 2020 won't be eligible to apply for the settlement status, but will need a working visa post 30th of June 2021. As employees aren't allowed to ask employers for visas yet and are not planning on obtaining a sponsor licence, what would happen after the 30th of June in regard to this employee being unable to obtain settlement status or get sponsored?
Good question. Fortunately, I don't do immigration advice, but you'll probably need to get some specific immigration advice in relation to that, because if you're not planning on getting a sponsor license, then I think you could be in some difficulties retaining them in employment. You probably do need to take some specific business immigration advice on that. And if you're interested, you know, there are various businesses around who will provide that fairly cheaply and competently.
Brilliant. Right, I think that is all the questions for now. Catherine, thank you ever so much. Remember, the webinar will be on our LinkedIn page. So I'm sure everyone will join me in thanking Catherine. Some really useful and interesting content there. And thank you to everyone else for joining us too. I hope you found it useful and we look forward to working with you in the future. Please do get in touch if we can help at all.